The Janine Turner Show, All-American Common Sense on KPRC AM 950, Houston's more stimulating talk radio. Well, the Supreme Court made a decision today striking down the Defense of Marriage Act, which I have to say was predicted. It was a 5-4 decision, and Chief Justice Roberts, Samuel Alito, Scalia were three of the four that were dissenters. And once again, Kennedy was a swing vote. So it's what are your thoughts about this? 855-952-6463, 855-952-6463. I'm just sort of I'm a states' rights gal, and I just think the states should still be able to make their own decisions. And I'm just curious how the federal law now, with the Supreme Court decision, is going to influence that. And don't forget, it won't happen, I believe, in this incidents. But the Supreme Court's not the be-all, say-all. If the legislative branch wants to come back and pass another law, they can. In Obama's statement here, he did say, he pointed out that the different people's points of view about this, and that the religious institutes do define and consecrate marriage. Has always been up to those institutions. And he said nothing about this decision, which applies to only civil marriages, changes what religions want to do. But that'll be an interesting question, won't it? It's like if this becomes, if it's legal in the state to churches, what are the rights of the churches? And we have a special guest with us now, Doug Uloff. He's a lawyer and a legal analyst regarding constitutional issues. Doug, welcome to the Janine Turner Show.
Thank you for having me.
This is always a big time of year, June, because the Supreme Court makes all these startling decisions, one of which last year was that they were going to uphold Obamacare. I remember I stood up out of my chair and just almost passed out. The world went black. What are your thoughts about this one? Well,
this one is, I think, in support of the doctrine that you mentioned earlier, states' rights. The Supreme Court is basically, I think, with this decision, the Windsor decision, and the Hollingsworth, to some extent indicating it's going to look to states to control these issues and not really the federal government. The particular decision, Windsor, struck down Section 3 of the Defense of Marriage Act, defining or creating a federal definition of marriage and what marriage and spouse mean in connection with the application of federal laws, but it doesn't go into states' issues. And in fact, I think the other decision that came down today sort of telegraphs that they may be looking to states to decide these issues.
Yeah, well, we didn't talk about earlier. I had another guest on talking about this, but we didn't really touch on their decision on Proposition 8. So will you fill us in on that a little bit on the Proposition 8 situation out of California?
In California, the California Supreme Court had ruled that California could not limit marriage to opposing sex couples as a violation of the California Constitution, and in response to that, California voters organized a ballot initiative that was known as Proposition 8 that did create an amendment to the California Constitution defining marriage as being between a man and a woman. Mm-hmm. That was challenged, and in the federal district court in California, the federal court threw it out, said that was unconstitutional, and the Governor then, Schwarzenegger of California, declined to defend that on appeal. So persons who had sponsored that proposition followed through on the appeal, tried to challenge that, and the court today decided that they didn't have standing.
Okay, so let's go back just so I make sure I'm following you. Proposition 8 was by the people. They voted in California, and they decided through Proposition 8. And their propositions become binding, unlike in Texas. We have propositions, but ours are just sort of like surveys. They're not legal. But am I correct in saying that in California, if the proposition passes, it becomes law?
That's correct.
Okay. So the proposition became law, but that's the irony there. That's what sort of drives me crazy. I mean, the people spoke, they made it, so it became okay. But now they want to take it to court, and you're saying that the court said it wasn't constitutional. What part of that Proposition 8 what did they mean it wasn't constitutional?
Well,
the state court.
The lower court declared it as unconstitutional, as violating equal protection of the law. But when it was appealed by this particular...
What was unconstitutional? The fact that they had done Proposition... So they did not agree with Proposition 8? They said Proposition 8 was not constitutional?
Exactly. The federal court upheld or basically struck down Proposition 8, even though it had been passed as a voter initiative in California. And the Supreme Court basically, it's a deceptive opinion in the sense as it looks like the Supreme Court is striking down or supporting the lower federal court in striking down Proposition 8. But ultimately, if you look kind of behind the scenes at what's going on, they're basically, I think, in both of these opinions, if you work through the dissents and the concurring opinions, there's sort of an indication that they're going to look to the states to decide what marriage is and is not. So although superficially it looks as though by leaving the lowest decision in place, striking the law, it's actually paradoxically may be telegraphing that the next time these issues come up to the Supreme Court, at least, they'll be looking to support whatever the state has done as opposed to imposing a uniform federal standard.
So on what ground did they say that Proposition 8 wasn't constitutional?
I'm sorry, today? No. Today they didn't get to the issues.
No, I'm saying in the lower court they said it wasn't constitutional. I'm still trying to figure out why they thought it wasn't constitutional.
I believe that the basis was they felt like as it was not allowing equal protection for all citizens to deny the ability to marry or have their marriage recognized, whereas this opposing sex marriage could be recognized. So
then it becomes, if we just stick with the state of California for a little bit, and we're speaking with Doug Uloff, he's a lawyer and a legal analyst about the United States Constitution, and thanks so much for joining us today, Doug. Big day here. I think that isn't that interesting when the people speak? Of course, it's different. It's not through representation when they do these propositions. It's more of a democracy type of thing. It gets in California in a lot of trouble, actually. You know what I mean? But it's just interesting to me that they would strike that down when the people had spoken.
It is, and the federal court, the lowest level federal court, did exactly that. It appeared to, as I recall, it was a hotly contested, and it split along 49%, 51% lines in terms of the vote, but nonetheless, 51% of those voted in favor of amending the California Constitution to define marriage as being opposite sex. So, you're absolutely correct that does seem to be a blow to the states' rights or federalist concept in terms of how the lower court handled it, and that decision is being allowed to stand. But in the bigger picture, they may come back and say, California, if you did this differently and someone supported it, it's kind of a strange situation because the people in California voted the proposition in, but then the elected officials didn't defend the proposition.
Didn't defend the people. Yeah.
Yes. So, yeah. I mean, that would be a reason why those elected officials might not be there the next election, but unfortunately, that doesn't always seem to be the way things work.
Yeah, these propositions are interesting because in Texas, our propositions are not legally binding. You're in Texas, right? Aren't you, Doug?
Yes, in Dallas.
Yeah. Okay. So our propositions aren't binding and they're not law.
Correct? That's correct.
Right. So, but in a way, I think that there's so many different ways to look at this entire thing. But to stick with Proposition 8 for just a minute in California, on the one hand, you can say, well, the people spoke and they weren't backed up by their representatives. But on the other hand, this is we rule through we're a republic where the people rule through the representatives. We have a representative form of government, and the reason our founding fathers wanted that is because sometimes people make decisions based on passions instead of reason, and they wanted for us to have elected officials that could actually see the whole workings of the government and understand it more thoroughly, and yada yada yada. Right. So I think California has actually also gotten themselves in a lot of trouble by voting in budgetary measures that they couldn't afford. Correct? Through these propositions, you're like, hey, free bread for everyone, sure. And not, I mean, sarcastic, but next thing you know, they're broke. California's broke because the people really didn't understand, the machine, the mechanism, so to speak, of how the government worked and what kind of what the budgets were and what kind of money they had. Am I correct in that assessment?
I believe so. California has previously had problems arise on budgetary grounds for particularly property tax initiatives where they restricted the ability of the state to tax property owners for the ownership of property. As in Texas, we would have property taxes as most of the way that local areas raise their money. And they limited that in California, and it backfired. There was also, as I recall, a controversy at the time Proposition 8 was considered It was believed to have the wording and how the proposition was put to the people in the initiative was challenged a couple of different times because it was deemed to be possibly deceptive or unclear as to, like a yes means a no and a no means a yes. We've had that happen a couple of times in initiatives up in the Dallas area where voters have been asked to pass amendments that might not be clear in how they're worded. And that was one concern in California when this Proposition 8 came up as to whether it was worded in a way that was
correctly. Yeah, interesting.
Understandable to a voter who wasn't reading deep enough into the language.
Well, they can be pretty tricky, and that's true. And we're speaking with Doug Uloff, who's a Texan. He's a lawyer and a legal analyst on constitutional issues. So, is California the only state that where their propositions are deemed then binding? Or are there any other states that do that?
I don't believe it is the only one, but I could not give you a list of how many. My recollection is it's not a long list, but I think there are other states that allow
some others that do. Yeah. Well, I think that I'm actually not a fan of the propositions because I think that it's more of a democracy instead of a republic, and I think a republic's definitely a better way to rule. Okay, so what do you think's going to, or not to rule, but to have a self-governing people for it to really work? I mean, it'd just be a big mess if all of a sudden people who didn't really know about the issues, or as you say, couldn't really understand the way it was worded, suddenly we're making huge decisions about the future of the country when we really don't have the knowledge that someone who goes to D.C. really would understand, or even to our state legislatures for that matter. So I do believe in a republican form of government instead of a democracy. And so many people think we're a democracy, don't even realize we're a republic, but I digress. So here we have this decision. Do you think this decision today, striking down the Defense of Marriage Act, will affect states like this? Let's just stick with the state of Texas, with Texas' ability to, make their own decisions about whether they endorse same-sex marriage or not?
I don't believe that it will have that effect. And interestingly, what didn't happen is, in some senses, as significant as what did. The court did not strike down Section 2 of the Defense of the Marriage Act, although it was invited to do so by the parties in the initial litigation, and that provision is one that says that the states are not required to recognize marriages that may be legal in a sister state. So, for example, New York may recognize a same-sex marriage as being a, quote, marriage, but Section 2 of the Defense of Marriage Act does not require Texas to afford a New York marriage that same status if the person were to move from New York to Texas. That remains in effect as being valid law and was not touched by the proceedings today.
Interesting. So if someone's legally married, a gay couple's legally married in New York, if they move to Texas, they would not be considered legally married, and they didn't mess with that one.
No, Texas is not required to recognize it, and I think under the state of law in Texas, it would not at this point.
Okay, and so that they did leave that alone. So states still have some sovereignty in that respect.
Yes, and really it's kind of the decision was fairly narrow in the sense that it only applies to federal benefits. So the Defense of Marriage Act, Section 3, basically amended a definitional statute in federal law that defined marriage and spouse. And that law applied to things like when one spouse dies and the property tax exemption or the marital deduction that the other is allowed to take against property so that they may receive property from the deceased spouse without taxation. That was actually the issue that was in play in Windsor. There also are going to be issues about Social Security benefits that basically the federal law will not now distinguish whether someone is a same-sex or opposite-sex spouse for purposes of federal benefits in federal law, but it doesn't touch any aspect of state law.
Yeah. Okay. So if you're married in a state that upholds same-sex marriage, then this federal decision coming from a federal Supreme Court will apply to you. But if you're in a state that doesn't endorse same-sex marriage, this decision won't, obviously, because there will be no legal binding civil union. And
that raises an interesting issue that to me is puzzling about the decision, one of the aspects that was used by the court in supporting this was to create a uniformity in the application of federal law. What's not clear to me at this point in time is if someone is married and they're in New York, and New York, therefore, you're not going to have a situation where the tax law would be dependent on New York law. They'll recognize that people are married. But it also sort of seems to indicate that, like, for example, if Texas, an issue came up where someone had a life partner that was same-sex, they're not going to be able to get, I think, advantage of that federal tax law because they're not married. It's not clear to me if the statute is going to pave the way to ignoring that disparity in treatment as far as federal benefits. I think probably the federal statute will now just uniformly allow that deduction to be taken, but it's not absolutely.
Well, and I think it's really interesting thought process that you just touched upon there, that we're all trying to feel our way through this a little bit, but I think that in itself, if the federal government comes into the state of Texas and says you have to give same-sex, these people who have these unions, you have to give them these federal benefits, would that not in a way be mandating, so to speak, or regulating that then the state has to accept same-sex marriage then?
Indirectly, it accomplishes that by allowing, a federal standard of marriage, which is exactly what the justices were saying they weren't doing. So it's. But
it seems like they may end up having to do.
Well, they're obviously, I think for state benefits, this isn't going to reach into that. And the states will still be allowed to define it. But as the state benefits may interact with federal level benefits, then presumably the federal non-definition is going to apply, or the federal avoidance of what that means is going to apply. So there's a lot of gray areas for how.
Yeah. So the states may be forced to do it after all, kind of through the back door there. Well, listen, Doug, I got so engrossed with speaking with you, I didn't even look at the time. But thank you so much for very, very insightful. I appreciate you, and there's really some great insights to this big decision today by the Supreme Court. Doug Uloff, thank you so much. You're a lawyer and a legal analyst on the United States Constitution in Dallas, Texas, and I appreciate you so much. Thank you for coming on.
Thank you for visiting with me.
Thanks, Doug. Wow, what are your thoughts? 855-952-6463 on the same-sex marriage being the big decision today of the Supreme Court. The Janine Turner Show, All American Common Sense.